When a debtor files a bankruptcy, the bankruptcy proceeding automatically stays or stops virtually any attempt to collect a debt or property from the debtor or to enforce claims against the debtor. However, there are exceptions to the automatic stay. First, proceedings to establish or enforce support obligations, domestic violence proceedings, paternity proceedings, and a number of other proceedings are exempt from the stay and may continue in state court even if there is a bankruptcy. Next, taken in violation of the automatic stay are void. Some courts have held that divorce proceedings may continue to dissolve the bonds of matrimony, since its equitable power is entirely within the province of state courts, but the automatic stay nonetheless prohibits the state court from making any property division. Therefore, the automatic stay continues to apply to actions to enforce property settlement. A bankruptcy court may sanction a willful violation of the automatic stay with damages, costs, attorney fees, and punitive damages. The bankruptcy court cannot discharge child support and alimony. Further, property settlement debts owed to a spouse, former spouse, or child are non-dischargeable under Chapter 7 of the Bankruptcy Code. However, property settlements in Chapter 13 may be modified, and the obligations paid at the same percentage all other creditors are paid in your Chapter 13 plan. In negotiating, drafting, and finalizing divorce judgments, it is important that your divorce attorney should be alert to the potential impact of bankruptcy. It is important that you always consult with a bankruptcy attorney if you are planning to get a divorce prior to, during, or after filing a divorce case, or if a spouse has filed or is filing a divorce case, you should also speak to a bankruptcy attorney. Many times, the divorce attorneys aren't familiar with the bankruptcy laws and may fail to maximize the advantages in your divorce judgment due to his or her unfamiliarity with the bankruptcy laws. If you are filing a bankruptcy with your spouse during a divorce, you cannot use the same law firm as both your divorce attorney and bankruptcy attorney without the other party's consent. However, an attorney experienced both in divorce and bankruptcy will be more perceptive to negotiating, drafting, and finalizing divorce judgments that anticipate the potential impact of bankruptcy. In contested cases, divorce lawyers should consider asking the divorce court to make specific findings of facts and conclusions of laws on the record to clarify the need for support and to clarify the obligations that are intended as support. In many cases, it's appropriate to include an anti-bankruptcy clause in a divorce judgment. These clauses reserve or create a spousal support obligation that will arise if a property settlement obligation is discharged in bankruptcy.